Mr. Klopp?
Good morning. Chief Justice Marshall and Associate Justices, may it please the Court. My name is Joseph Kropp, and I represent Legendary Marine, the appellant. Briefly, the procedural history, which is simple, is the Superior Court granted our motion to dismiss on personal jurisdiction. The Roberts appealed. The appeals court reversed the Superior Court, finding sufficient minimum contacts for due process. We're now here after this Court's grant of further appellate review. The facts here, I think, are critical, and I will try and concisely repeat them to emphasize them. Legendary Marine is a Florida boat dealer. The only sale they ever made in Massachusetts was this boat. They have no offices here, no employees here. They don't advertise in any media targeted at Massachusetts. 80% of their sales are in Florida, 15% in Alabama, and the balance in southern states. Excuse me. Their primary advertising is in a North Florida publication called The Boat Trader. They are also on the Boat Trader's webpage. In 2002, this webpage carried 75,000 boats. Legendary was 35 to 40 of the 75,000. It's a passive webpage. It provides the email address and a local phone number for Legendary Marine. It doesn't even provide an 800 number. Completely passive. Turning to the specific facts here, Roberts sees the ad for a Legendary Marine boat on the website. They call Legendary Marine expressing interest. There are some telephone calls. Roberts then hires a Florida boat surveyor to go to Florida, to the Florida site of Legendary, to inspect the boat. Robert agrees to buy the boat over the phone. The contract's sent back and forth by mail. Robert hires and pays a Florida shipper to send the boat back to Roberts in Massachusetts. The reason the facts are key is that they are essentially indistinguishable from the Drukas case. In the Drukas case, decided by the SJC some time ago...
When he called him down there, did they discuss the boat?
The record indicates that there were telephone calls that relate to the boat.
Does
Correct.
it say what was discussed?
There's a dispute on that, but the Roberts say that there were certain representations made, despite the fact there's a written contract which says this is all the terms, there's no other oral representations.
So what I'm coming to is accepting, assume we accept for jurisdictional purposes what Mr. Roberts says, and he says misrepresentations were made that had an impact in Massachusetts, on a Massachusetts buyer. Is that good enough?
That's not good enough. There were misrepresentations made in Drukas, and it was not good enough. The misrepresentations in Drukas were the engine's in perfect condition. It turned out it wasn't. It had saltwater damage, and it was defective. Same problem we have here. They claim there were misrepresentations, which we deny. I accept for jurisdictional grounds. We're stuck with them. And in Drukas, there's an additional fact which strongly supports, or more strongly supports, finding jurisdiction than here. In Drukas, they advertised in a publication directed to Massachusetts buyers. That's not the case here. We're on a passive website. We're not directing anything to Massachusetts buyers. They're coming to the website, in this case the first one, and looking at it here. The SJC concluded in Drukas, referring to the sale of these two engines by the Florida boat dealer to somebody in Mass, similar to this one sale here of a boat, we would not consider that transaction isolated in nature and void of any other significant contacts with the Commonwealth to be an act by which the defendant purposely availed itself of the privilege of conducting activities within the forum state.
But in Drukas, we looked at really 3A and 3B. We didn't look at 3C, did we?
You didn't look at 3C, that's correct, but you also had to make, in order to find jurisdiction, that it satisfied the minimal due process requirements. There was a finding...
Well, certainly if there's only one contact, but that contact is a tortious act in Massachusetts, isn't that enough?
I would say it's not, Your Honor, for two reasons. First of all, I deny that it was a tortious act here because the gist of the complaint is contract. Judge Bornstein concluded in his decision that this is a contract matter, not a tort matter.
I saw that. So what does that mean? The gist is a contract even though there are tort claims?
That's right, because you have to make an overall decision. Is it a contract case or a tort case? Overall, I suggest Judge Bornstein's right, it's a contract case.
You have to make an overall decision for what purpose?
For purposes of deciding which of the three A, B, C, D apply.
You have to make a decision. It could be equally tort, equally contract, more tort than contract, more contract than tort. You have to make a decision that it's one or the other?
I believe you do. If in the Intech decision, there's a reference in a footnote that the court decided, and pardon me, I don't recall if it's the SJC or the appeals court decision, but there's a footnote where they say, and I believe it's the appeals court.
In Intech?
Give me a moment, Your Honor, I apologize. I can't remember which case, it's in either Intech or Remp, but they cite Barber versus Fox, a case in a different area, that you have to decide essentially whether you've got a contract or tort case. I say, Your Honor, that you have to make that decision. Even if you take the position, for argument purposes, that you can have both, I would suggest that you cannot find on one misrepresentation that there is enough for due process. In Drukas, the misrepresentation is prominently discussed in the decision, but the conclusion is there are not enough contacts here for due process. In the SJC's decision last year in Intech, and I quote, if the literal requirements of the statute, the long-arm statute, are satisfied, it also must be established that the exercise of jurisdiction under state law is consistent with basic due process requirements. So that even if literally you may fall within A, B, C, or D, even C or D, which have to do with tortious acts, you still have to satisfy the minimum due process requirements of the federal Constitution, which is the limits of how far the state can go. So I don't think it matters, although I would argue that it is a contract decision.
Well, is it because it's a misrepresentation which doesn't look like perhaps too serious a tort? Surely if it was an explosion or some other tort that resulted from a single contact,
that would be I would view that as a tort matter. If you're talking about a products liability case or a personal injury case, that would be a different analysis. That would be a tort matter.
Essentially, as I understand your argument, Mr. Klopp, is that any time one sale with which into a state, Commonwealth, one out-of-state sale into the Commonwealth, and if the buyer is dissatisfied with it, can essentially say, this is a misrepresentation, this is a tort, therefore I've got around the long-arm statute, correct?
My position is if you decide contrary to my, if you go against me, that's right. Anybody could make an argument and file any unverified complaint. The complaint would say there's a misrepresentation. The complaint has to be accepted for, unlike a motion to dismiss generally, on a motion to dismiss for personal jurisdiction to jurisdiction, you accept the complaint in the affidavits, although the cases say there's some viewing of the complaint in the affidavits. But every single person could get into this court by saying in the complaint there was a misrepresentation, Florida, Arkansas, Alabama, I want to bring those people up here. You would essentially have universal jurisdiction in Massachusetts for an isolated transaction if all they did was give the magic talisman, tort.
Or misrepresentation.
Or misrepresentation. Correct.
Right?
How do we then, I mean, the appeals court put great weight on First Circuit decisions on this very subject, Murphy and Ealing. How do you say those are not right?
The reason I say they're not right is several. First, Murphy was decided pre-Drukas. And in Murphy, the court stated, the reach of the jurisdiction of the mass courts under Chapter 223A, Section 3, has yet to be delineated by the Supreme Judicial Court. We are therefore required to interpret that chapter, our long-arm statute, without such guidance and only with the aid of other state court opinions. They acknowledge in there's no guidance yet by the SJC. It's pre-Drukas. We're going to look at other state court decisions.
But we've said that Section 3 is to be read in essence to extend jurisdiction as far as due process will allow.
Correct.
So I assume that the First Circuit wasn't going beyond what due process would allow.
It wasn't, but they didn't have any guidance as to how far Massachusetts would delineate that fine line.
Was
So-
there a due process claim raised in Murphy?
I don't recall, Your Honor.
That's okay, we can check.
Well, it's a jurisdictional case.
It was a
Personal
jurisdictional case.
jurisdictional
Whether it was
case.
specifically addressed or not, they had to
Civil
ultimately
case, if you don't-
find.
if you don't raise the argument, you don't get it.
Well, I mean, jurisdiction was challenged.
Well, if jurisdiction's challenged, the court, even if I would suggest the party doesn't raise it, has to address both, meeting the long arm and meeting due process, otherwise they can't find jurisdiction. I would say if I came in here today and I was on the other side and didn't argue due process, the court would still have to do a due process analysis.
Maybe yes, maybe no. Why? This is
Well-
a civil case.
But to establish
I suppose
jurisdiction,
you can
it needs-
waive it, but I'm not sure you can waive jurisdiction.
All right.
It would be raisable at any time. I'm sorry.
Explain to me how
Of course you can
you,
waive in personam jurisdiction. You can't waive subject matter jurisdiction, you certainly waive in personam jurisdiction.
But I think if you could
You're-
still...
You're winning if you go with me, so don't argue with me.
no, I'm just trying to understand
I understand, Your
why you think
I'm with you, Your Honor.
that is different.
Let me talk about Ealing for a second.
Okay, we'll go to Ealing then. We'll start with Ealing.
Ealing relies on Murphy and other federal cases.
That's why I'm starting with Murphy, but that's okay.
I'm sorry. Murphy and Ealing are both without the guidance of any of our decisions here in Drugas. They don't discuss Drugas. They don't discuss the due process reach the way it's been analyzed here. The only mass case cited in Ealing is Morrill versus Tong, which has no argument of due process and is a child support custody case about bringing in a parent within the jurisdictional bounds here.
But Ealing is about a fraudulent telex from England to Massachusetts.
It is. It is. But I just emphasize that neither Ealing nor Murphy have any benefit of the decisions of this court.
I have to say...
Well, Drukas
having
was
read
decided
the-
long before Ealing.
Having read the appeals court decision in this case, I'm absolutely confident that a due process claim was raised in Murphy because the appeals court state that there is no constitutional objection to Massachusetts citing Hansa against Steckler, and I would
Right.
say that absolutely there was a due process claim.
Clearly. Correct.
Well,
So
I mean,
even
what
if-
Ealing says, and relies on Murphy, it says, in Murphy we held where a defendant knowingly sends into a state a false statement intending that it should be relied upon to the injury of a resident of that state, he has, for jurisdictional purposes, acted within that state. And you're saying that's no longer the law after Drukas, and
That's no longer the law in Massachusetts. Maybe the First Circuit can apply it someplace else, but I don't know how they could decide that after the decision in Drukas. The appeals court also relies on, the appeals court also distinguishes the REMF case from 2004, another Florida boat dealer case. I'm not sure why there's such a rash of them, but I guess that's where all the boats come from.
all the money is.
True. In REMF, which was governed by Drukas, the appeals court stated, the defendants in the instant case did not purposely avail themselves of the privilege of conducting business in mass by their acts of advertising nationally and responding to the inquiries of a prospective purchaser who happened to live here. Then they go on to distinguish REMF on very narrow grounds where they say, but in Roberts, in REMF, the plaintiff went down to Florida, the plaintiff was doing more in Florida. It's not the plaintiff's actions that are the focus, it's the defendants. And for that reason, I think the distinguishing of REMF is not appropriate. Justice Liakos in Good Hope some time ago specifically referred to the acts of the defendant being the key, and Good Hope is still good law.
Am I correct that in REMF that boat seller did advertise on various Internet websites?
In REMF, it was on a written publication distributed in mass. Again, like Drukas, they're targeting Massachusetts. Unlike here, we are not targeting Massachusetts. We have a passive website. And although we haven't briefed this, and there's been no question about it, the vast majority of the law that I know of, and I don't know anything to the contrary, a passive website alone does not give you enough. The law is very different in developing on an active website, but a passive website doesn't, because obviously that would mean all 50 states could be brought in here.
When you say passive, would you explain what that means? That's a website where anyone can look at it, but there's no interaction?
I'll give it a try. My 13-year-old twins could probably describe it better. But a passive website is one where you view it and you don't then use the site to do anything. The active website, you can start making an order, getting information. This website...
Well, when you view it, though, you get phone numbers, addresses, so...
Correct. But then you have to go pick up the phone.
Which is what happened here.
That's right. They viewed it on the website and then called.
Would that make a difference, really?
If it was an active
Is that
website?
Active, you mean that just means you can, through the website itself, contact the seller. Why does that make a difference?
I think with enough other information, that would be one more fact you would look at to see if there's enough contacts. I'm not sure that it would be enough.
When I think of active website, I think of one that pops up on my screen unwanted when I'm trying to do something else. Now, that's an active.
That's overactive.
Trying to sell me whatever.
Thank you, Mr. Clark.
Thank you very much.
Can you give us,
The Eustace?
Madam Chief Justice and Associate Justices,
give
may it
us
please
in
the
maybe a
Court.
minute or two what facts you rely on to establish jurisdiction?
Certainly, Your Honor. My brother's summary of the facts were certainly accurate. There were some facts that were not noted in his brief recitation of the facts, which I would wish to note for the Court. First, the Roberts did learn of this boat through an Internet advertising. I would disagree with the weight that my brother puts in his argument on passive website versus non-passive website. Certainly no one has the ability to stop the information once it's placed on the World Wide Web to stop at the state lines. And even a novice in these matters understands that when an ad is placed on the Internet, that ad is inviting potential customers from beyond that state.
Passive website, are those words a term of art? Are they recognized in information technology as a term of art? Is there any information on that?
Not that I'm aware of.
Any cases to describe this kind of website as, quote, a passive website?
Not that I'm aware of, Your
So
Honor.
if we call it passive, we'll be coining the first use of the term?
That would be my understanding, Your Honor. What I would suggest the Court interpret Internet advertising
I mean,
as
this is really no different than a magazine, is it? Where you've got an ad in it, and it says, here's the phone number, and here's the boat we're selling? It's just that this is up on a monitor.
I would suggest it may be even more difficult to track where that is disseminated, whereas a magazine may be easier to. But once something is placed on the World Wide Web, anybody with a computer terminal and Internet access
Sure, it
is
has
going to be a
much wider
potential customer.
distribution. It can go all over the world, whereas a magazine has to be shipped in.
Mr. Eustace, would I be correct in concluding from the statement that you have just made that it will be consistent with constitutional principles for Massachusetts to summons in any person from anywhere in the world to Massachusetts, because for these purposes they're no different from Florida, if they purchased something as a result of seeing an advertisement on the web, and when the good arrived, that person alleged that there was a misrepresentation?
If the advertising contained a misrepresentation and there were subsequent discussions and negotiations between the party and the merchant, as there were in this case, I would say yes, Your Honor. Here there were extensive negotiations via the telephone and emails between the Roberts and the boat dealer.
So the answer is no if it's simply a question of I'm sitting in Canada, let's take an easy one, or Mexico, they're close. I see the web page, I phone or fax or send in my order. The product comes, I don't like the look of it, and I allege that it is inconsistent with what I read on the web. You would say not enough.
Well, Madam Chief Justice, it may be if the misrepresentation were as clear as it is in this case. In this case, it's an easier question to answer because those initial misrepresentations in the advertising, and there's no dispute that they were, this was advertised as a boat with 10 hours, and that portion of the ad was in all caps within the ad, deal of a lifetime, boat and engines only have 10 hours. And there's no factual dispute that they don't. In fact, the defendant in the case simply asserted there's no difference in value between a boat with 10, 14, or 74 hours, which we would suggest is absurd.
But it doesn't matter because your client thought he or they were buying a boat with 10 hours, and for
That's
them,
correct.
10 hours is different than 11 or 100 hours.
That's correct. In this case, there's no question that the advertising, if this wasn't a matter of somebody's dissatisfaction with the way a product looked. This was a material misrepresentation that induced my client to purchase the boat and affected the value of what they were buying. It was a material misrepresentation, and it was exacerbated by the discussions that my client later had with the boat when they were negotiating the sale price.
Now, let me just change the fact a little bit. If the boat were identified, year and model, but no representation were made about the condition of the boat, and your client had then called and a misrepresentation were made over the telephone, would that be enough?
I would suggest that it would, Your Honor. Again, it's not as strong a case, admittedly, as we have here, but if a misrepresentation were made, it were a material misrepresentation, it were made with intent, as is clear on the record was done here, and the plaintiff relied upon that misrepresentation, then I would suggest we're in a Chapter 233A, Section 3C situation where we have a tortious act within the Commonwealth based on that misrepresentation.
Tell me about the later communications and why we should look at those communications. After your client received the boat. You said they were back and forth with was that before or after they received?
Before, Your Honor. There were numerous telephone conversations during the negotiation of the purchase.
How many calls came from the defendant to your client here in Massachusetts?
Initiated by the defendant,
Yes.
Your Honor? It's unclear in terms of the quantity and where they originated, although from the affidavits it's clear that there were calls at various times initiated by each party.
But it's your claim that within those communications initiated by whichever party, there were further misrepresentations, or put it this way, there were confirmations of misrepresentations.
Yes, that is correct. That is clear in the plaintiff's affidavit. And beyond that, beyond the advertising, beyond the telephone calls which induced my clients to purchase this, we had a purchase and sale agreement which was sent from the defendant to the plaintiffs in Massachusetts, which contained within that purchase and sale agreement misrepresentations. The P&S described the boat and the engines as new. So we have not only the advertising, not only the telephone conversations, we have the mailing of a written document, the sales contract, which contained within it misrepresentations, which we would suggest clearly puts this within the realm of Section 3C.
If there were no web page and there were no advertising, and this transaction were initiated by a friend of your client's who was down in Florida and happened to see a sign that says boat for sale, and came back up and told your client about it, and your client then made a telephone call down to Florida, and then the deal proceeded just as it did in this case, would that be enough to establish long-arm jurisdiction?
Admittedly, it may not be, Your Honor.
So you need to have the web page in this case in order to get your foot in the door.
Well, I think what you need, based on the appeals court's interpretation of the REMF case, is you need the locus of the misrepresentation to have occurred in Massachusetts. That case is distinguished by the appeals court because in that case the plaintiff first saw the boat in question when the plaintiff, a Massachusetts resident, was physically at a boat show in Florida. He also did a sea trial himself personally while he was in Coral Gables, Florida. So in that instance, the misrepresentation was done arguably within the state of Florida. That case is distinguishable from where we are here because both plaintiffs never traveled to Florida. They never left the state. The defendants knew they never left the state.
But
So
their
these-
agents were in Florida.
That's
They
correct.
hired someone to inspect the boat
They-
on a couple of occasions.
They hired one surveyor to inspect the boat. They were actually referred to that surveyor.
Doesn't
by the
matter where they were
defendants.
referred. They decided to hire that surveyor, became
That's
their agent,
Correct.
inspected the boat,
Yes.
actually found that there were more hours on the engines than your client had thought.
No.
right? 14 hours.
Correct. Yes.
So the sale went forward.
Yes.
And then when the boat ultimately got delivered, you had it inspected. Then you had it transferred to a Florida boat company that brought it to Massachusetts, right?
Yes, Your
So
Honor.
you took possession in Florida, brought it to Massachusetts, had another inspector look at it, who said, no, there are more hours on these engines.
When they brought it to Massachusetts, the first day they attempted to use it, the engines essentially didn't function. The boat broke down. They had it brought into Pier 37 in Falmouth Harbor, and the boat was connected with a computer diagnostic device that the mechanics use. These engines have a memory in them, and when it was connected to the computer, the actual hours were revealed.
Well,
and that's when they first learned that
I
they
assume that the boat
71.76 hours.
wasn't driven from Florida to Massachusetts, because that might well account for the different hours.
That's correct. It was shipped via a trailer,
Okay.
Your Honor. It was not
Mr.
navigated to Massachusetts.
Mr. Eustace, I realize that Lucas didn't specifically deal with 3C, but with respect to the due process claims here, and I'm just quoting, we went back to Hansen against Denkler, which is, as you know, the foundation case. And this is what we said in Lucas. We view the sale of the engines to the defendant as an isolated transaction with slight effect on the commerce of the Commonwealth and is void of any purposeful intent on the part of the defendant to avail itself of the privilege of conducting activities within the foreign state. So I go back to Justice Spina's question. Is what makes this case different the fact of the web page? Because in Lucas, there were lots of back and forth, as I recall, too.
Well, in Drukas, my reading of Drukas, Your Honor, is that it's unclear that there were actually extensive discussions. I think there was at least one telephone call.
Well, what we seem to be focusing on Lucas was not how many back and forths there were, because, you know, one person could have a 2-hour telephone call and somebody else could have 20 10-minute telephone calls. But you've sort of got one sale, and I think that was Mr. Klopp's argument. We weren't targeting Massachusetts. We didn't want to come to Massachusetts. This is the only sale we've got here. All of our stuff takes place, in the southern states. And if you happen to know about a boat, either because of a web page or because your friend happens to be down in Florida, this defendant is not purposefully availing itself, the classic language, of the benefits and protections of Massachusetts law.
Admittedly, Drukas all but makes moot the argument advanced in my brief that 3A and 3B should apply.
No, and the appeals court said they don't.
Yes.
But what I'm trying to look at is the umbrella of due process when you're looking at A, B, or C. And so why wouldn't we use the same umbrella when it comes to C?
Well, in looking at 3C and the due process argument, Your Honor, and to answer the question that you posed to my brother earlier, the First Circuit case of Murphy did, in fact, specifically address due process.
Yeah.
And what they found was where the defendant has the intent necessary in a misrepresentation claim, the defendant intends to misrepresent somebody in a foreign state, they are waiving any claim at that point in terms of fairness in due process from being hailed into that foreign state. And Murphy addresses this issue specifically. It says where there's an intentful misrepresentation, due process is not an issue. It comports with due process if that happens. And here...
But when a person creates a web page for commercial purposes, does that in effect satisfy the Drukas requirement that the person intends to avail himself of the privilege of the commerce of every state in which the website appears?
Well, I think if they intentionally misrepresent what they're trying to sell, they do. In this case, they didn't have to place an ad that misstated what the hours were. They didn't have to call the boat new continuously during the negotiations, and they didn't have to send a purchase and sale agreement that described the engines as new. Each and every one of those actions on the part of the defendant were misrepresentations, and the plaintiffs would suggest when they did so, they were then availing themselves of that jurisdiction.
So you would say then that the jurisdictional argument depends on the content of the advertising?
If you're only relying upon the advertising as your misrepresentation, yes. In this case, we have advertising, pre-sale communications, and a contract sent to the foreign state, sent to Massachusetts, which contained misrepresentations in it. That contract was signed by the plaintiffs in Massachusetts. And again, it was a written communication to them in a foreign state which contained misrepresentations, which puts it within the purview of 3C.
So you seem to be saying that, look, this is a tort, and you can put aside all this stuff about, how much contact was established with Massachusetts, because the tort was committed in Massachusetts, and that's enough.
That's correct. This is a misrepresentation case. The misrepresentation induced the plaintiffs to buy this boat. Their claim is that what was represented to them was false. This is not a private sale. This is a business that is in the business of selling boats. They knew this wasn't a new boat when they sold it to the Roberts, and it's at heart a misrepresentation case. And the Roberts had never left Massachusetts throughout the course of this transaction, so the misrepresentation happened in Massachusetts.
Thank you, Mr. Eustace.
Thank you.
Take a short break.
All rise.